Okay. So first of all, any comments from anybody? Any problems that you're having? Any forms problems? This is the reason this class is called Forms and Free for All Monthly, is because we give you an opportunity to,
I think so, yes.
you know, to share any struggles you're having, and it doesn't necessarily have to be about forms.
Well, I just bought a piece of property that I'm going to subdivide out.
Okay, I muted Jill for her. Okay. Okay. Anybody have any comments? Anything that's been on their mind that they would like to ask? We have Jeff and myself both here today, and so we're always happy to answer your questions, or you can call us individually, however you want to do it.
Good morning. I was calling to see if you guys knew of a program that I could use for signatures. I'm only with the.
Yes, that's a great question. And the program that we are using for electronic signatures is provided on utahrealestate.com on the MLS, and it's called SkySlope. The e-signature piece is called DigiSign. So if you don't know how to use that yet, there's a few ways you can learn. Number one, in fact, let me go in and share my screen.
Hey, Don,
Yeah.
she was going to say who she was with. Are you up north and have Utah Real Estate Access, or are you down in one of the southern offices?
I am in Iron County.
She's on the Iron County MLS.
Ah, well then I don't know if they have it or not. Do you, Jeff?
They don't. So she would be looking for a different signature platform.
Clay on the same thing.
Do you know what?
If we get
Iron County, I think, doesn't Brett handle Iron County?
He does.
Call your broker, call Brett Taylor, and he can give you some ideas on signature platforms that would work well. Okay.
Yeah, thank you. What's your email again?
Hey, Matthew, we need to have you mute.
No problem. We were just talking.
You guys, can you all mute your microphones? I'm going to have to mute everybody, I guess. Mute your microphones unless you're asking a question, okay? Otherwise, it'll be pandemania. Okay, so I think I've got everybody muted. So, well, for those of you that might kind of have the same question, let me just show you a wonderful thing about utahrealestate.com. So first of all, to get to the electronic signature piece, if you go to forms and you go to SkySlope forms, there are some steps for you to get to the electronic signature piece. There's a couple ways for you to learn how to do that. If I'm your broker, you can call me. If Jeff's your broker, you can call him, or you can call either one of us, either way. But the cool thing is that the MLS provides helps as well. So if you go into help, click on the help tab and go down to support center. Okay, in the support center, it's coming up, hang tight. Okay, you can type in SkySlope, or you can just, there we go. Here's the SkySlope webinar, getting started with SkySlope, signing in, SkySlope Help Center, SkySlope frequent asked questions. So there's a lot of helps in here for you. Or you can, a shortcut to get to it is just to scroll down, because there's not that much stuff. Okay. If you scroll down until you find the SkySlope tab, let's see, I probably passed it.
Right there on top.
Right over here, SkySlope tab. There are articles and there's videos that are really good to help teach you how to utilize SkySlope. Now, just a quick explanation. For those of you that you know that within 48 hours of getting a contract signed, whether it's a buyer broker agreement or a listing agreement, you're supposed to have that paperwork into IntelliAgent. So you're supposed to create a file and put it in IntelliAgent. Okay. So people are asking, oh, well, don't we have an electronic signature piece that we can just send it out from IntelliAgent? The answer is no, not yet. They're working on it, but it's probably several months out. And so for now, what we're suggesting that you do is go ahead and create your forms in SkySlope. Learn how to do it in SkySlope forms. I'm not going to teach you that today. Jeff taught that in our last tech class, and we can have another class or two on it. But create all the forms that you need, get your electronic signatures, and then you can either drag and drop them, or you can save them somewhere on your computer and drag and drop them, or upload them into IntelliAgent from there. Did I explain that right, Jeff?
You did.
Okay. So that's how you would do that. Okay. Any other questions? That was a good question. Any other questions before we go into some of the forms that I just want to make you aware of today? Today is called Awareness Day. Let's see. I thought I had this open up. I guess I didn't. I emailed myself all the forms that we're going to be talking on. So hang on just a second and I'll get that opened up. Goodness gracious. I cleared out all my emails. Okay, here we go. All right. So you guys, we have a different market right now, don't we? So, and because of that different market, there's a lot of different types of financing that people are asking for. And so we're going to go through a couple of those today. And the reason is because I've had agents call me and not know how to do this. So today is called Forms Awareness Day, okay? And I'm not necessarily, I'm going to briefly kind of touch on the forms. I'm going to challenge you. I'm going to challenge you to go in and read each of these forms that I'm telling you about, but I want you to be aware that they're here. In fact, there's a couple of forms that I found that I didn't even know were here. They must be relatively new forms. Anyway, for sale by owner, commission agreement, and agency disclosure. So first of all, how do you use this form? And when do you use this form? And so I'm going to answer that this way. First of all, if you have somebody that calls and says, hey, I saw a home that had a for sale by owner sign on it. Can you show me that home? Your answer should always be, of course I can. And then you're going to go and you're going to get the number off of that for sale by owner sign. You're going to call them and let them know that, hey, I'm not calling you to ask you for your listing. First of all, when you make a phone call, the first thing that you must do, it's a division rule, it's a state law, is that you must identify yourself. Hi, this is Don Zimmerman with Fathom Realty. Hey, don't worry, I'm not going to ask for you to list your home with me. I do have a potential buyer. Would you be interested if I bring you a buyer? Would you be willing to pay a 3% commission on the buyer side? I have never had anybody turn me down when I've called and made that offering. So this would be the form that you use. When you do the for sale by owner commission agreement, you can see it's called a commission agreement and agency disclosure because it kind of does all of that. Okay, so just like in your listing agreement or your buyer broker agreement, there's a section on brokerage fee. So first of all, you're going to describe who the seller is, you're going to describe the property, and then you're going to describe the brokerage fee. You're going to fill that in just like you do on a buyer broker agreement or a listing agreement. Then there's a protection period. People are uncomfortable with protection periods, and I don't know why. I have agents that are putting zeros in there. I wouldn't put a zero in there. If you want to be on the slim side, put at least 3 months in there. I usually put 6 months. And if you don't understand what the protection period is, read that, and it pretty much tells you. But I'm telling you that right now we are going through one that we're taking to small claims court with one of my agents up in Salt Lake, because what happens is if you cancel or if this agreement expires, okay, and then somebody that you marketed the property to goes ahead and buys the home within that protection period, the seller still owes you a commission. So that's an important number to fill in there. Okay. Then, question. Okay. Remember to turn off your microphones unless you have a question. Okay. All right. So there's warranties and disclosures. You can read through all of this, the agency relationships, professional advice. A lot of this is boilerplate from the other agreements that we normally that we normally have our clients sign. Dispute resolution. Okay, this kind of automatically they are agreeing that for sale by owners agreeing if there's a dispute, they will go through mediation first. That's a whole process that you probably don't want to go through, but it's what I call a cool down period. So if you ever get in a situation where you have a dispute with somebody, then we'll tell you how that works. Okay. So read through all of this attachments. When would you have an attachment for sale by owner agreement? What might be an attachment? Maybe it's, I don't know, maybe it's an attachment that the sellers want to make sure that you understand that the refrigerator is not included, or the, you know, whatever, any kind of explanations or anything. And there is now, there didn't used to be, there is now an addendum to the for sale by owner agreement. Okay, and we'll show you that here in a second. Anyway, pretty self-explanatory. A lot of it is boilerplate from the agreement that we have, whether it's a buyer broker agreement or a listing agreement. So this is another area that I have people question all the time. Don, do you need to sign it? Read what it says. Signature of authorized buyer's agent or broker. So you as the agent, you have the authority to sign it, okay? For sale by owners, there's a lot of different types of for sale by owners. And so if you have particular questions on that, contact your broker. Here's the addendum: for sale by owner commission agreement and agency disclosure addendum. So if you have, if you need to do an addendum to that agreement, please use the proper form. These are all in the MLS library, okay? Okay, so that's the addendum. Again, signature of authorized agent or broker. If this said signature of broker, then you would need to send it to your broker, okay? Next one is lease agreement with option for purchase. This is another one that I'm seeing pop up now more than what we were seeing 6 months ago, even 6 months to a year ago. So anyway, this is an agreement that someone can, they say, you know, hey, we need to work on our credit scores, whatever. And so can we lease the property for a year, and then we'll have everything ready to go within that year and be ready to refinance and cash you out. Okay. So this, I want you to read through this. This is an awareness day. Read through this, but I'm going to point out the different sections of this agreement. First of all, there's option money, and the option money is kind of the same as earnest money. This describes where that money is going to go. And so read through that. Offer to lease with an option to purchase. This describes the property, what is included with the property. The following items are excluded. So a lot of this, again, is boilerplate: water service, land disclosures, tenant's right to due diligence. The tenant's obligation to lease the property from landlord is or is not conditioned upon tenant completing it and approving a tenant's due diligence. So, you know, same thing as doing due diligence on a purchase, okay? Due diligence and the deadline talks about that. Then you come to the lease terms. The lease terms, you need to read through this very carefully. The term of the lease will start on such and such a date, and it shall end on such and such a date, or it will end on the closing of the purchase of the property by tenant, whichever occurs first. That's considered the lease term. Occupancy: tenant may occupy the property starting on blank date. And then the lease payments. How do you come up with a lease payment on a property? What is kind of the best way to do that? You know, some people say, well, I know I've looked online and I've looked on ksl.com, and for a 3-bedroom, 2-bath home, it's going for $2,500 a month. That's one way. Another way is if you take the purchase price of the home and amortize it over 30 years, your payment should be approximately maybe a little higher than what it would amortize over 30 years for, okay? So that's where you put the rent payment. Security deposits, late charge, need to read through all of this. There's utilities and other services. This, you're gonna specify who's going to pay all those. Is the tenant gonna pay it, or is the landlord gonna pay it, okay? Are pets allowed? This says that pets are not allowed unless it's in writing at the consent of the landlord. Maintenance and repair, who takes care of that? All of these things are important items, and that's why you need to use this document, because it has all of these things in here that protect both the buyer and the seller. Okay, entry and inspections, waiver, holding over. Holding over means that if you go past the time frame on this lease, then you're considered to be on a month-to-month. Okay, default section, landlord remedies for tenant default, insurance and risk of loss, tells who's going to hold, insurance on there. Generally, of course, you have the owner of the property that maintains the insurance because they're still the owner. And so this describes how that's going to work. Okay. Option to purchase. Now this section is the purchase agreement part. Okay. The purchase price of the property shall be blank. Okay. Read through this. It tells all about the option money, what's credited, what isn't. The notice of intent deadline. If the tenant elects to purchase the property, the tenant must no later than the notice of intent deadline referenced in section 24C provide the landlord with written notice of intent using the attached notice of intent to purchase the property form. We'll show you that when we get down to the bottom. Payment of purchase price, settlement and closing. A lot of this is boilerplate stuff, but read through it so you understand it. Special assessments are to be paid by who? Okay. If the seller still owns the property, of course. So I always put that any special assessment should be paid by the landlord until my buyer owns the property. Okay. Transfer fees, any transfer fees that need to be paid. But of course, all these things are negotiable. Closing, confirmation of agency disclosure. And then, of course, there's a section on title insurance, warranties and representations. If there's going to be a home warranty included, all of those items, you can read through it. It's pretty much the same as a real estate purchase contract. Additional terms, there are or are not. This is where you would put in, if there's addendums, you would put those here. Changes during the transaction. This just says that there can be no changes without written and prior consent of the tenant and the seller. Everything has to be in writing. Authority of signers, mediation, attorney's fees, all of this part is boilerplate stuff. No assignment. This contract cannot be assigned unless you have it in writing and signed by both parties. Okay, then here we go with the section 24. Landlord disclosure deadline is by such and such a date so that the tenant can do their due diligence. Due diligence deadline then is such and such a date. A lot like the REPSI, isn't it? Notice of intent. Remember the notice of intent? Notice of intent, if they're going to be leasing this property for a year, and it's a year from today, the notice of intent deadline would be maybe 30 days prior to 1 year. So it would be January 15th of 2024 would be the notice of intent deadline. And then settlement deadline, when that's going to happen. Okay. Then if you go farther down, here is the acceptance. And then if you go farther down below this, here's the notice of intent to purchase the property. So this is what the buyer, the leasee, would have to fill out if they decide that they are going to purchase the property. If they don't want to purchase the property and their lease is up in 1 year, then they would either move out in 1 year, or if the landlord allows them to stay in there, they can stay in there and it would be a holdover where they're charged month to month, or they can do a new lease agreement. Okay. But this is intent that in the contract it states that the potential buyer must present this to the seller
But we didn't get on
30
the.
days
some of
prior,
them, well, here's
30
part of
days
the,
prior to the expiration of the date. Okay.
railings.
Please mute your microphones if you're not asking questions. Okay.
Yeah, so some of them, I don't know. That
Can you mute your microphones, everybody? Let me
I will include you on email.
hold on. Okay, mute all. Okay. Okay, so now I've got all of you muted. Okay, this is the addendum that you would use for the lease agreement with option for purchase. So this is the particular agreement that you should use. And it's because it has some verbiage in it that will protect everybody. The Division of Real Estate says this. They say, if there is a form that is an approved form by the state of Utah, and it satisfies what you're trying to do, you must use that form. Or, there is an or, you can use a form that is written by an attorney. Now, if an agent says, oh, I can write an addendum, then you are taking the place of that attorney. And so you take full liability for that. Okay, so it behooves you to utilize the forms that are already available. Does anybody have any questions on the lease agreement, lease with option to purchase? Anybody?
Hi, Don.
Hi, April.
I do have a question. So if this contract goes on and they do purchase it, then is the agent responsible then for coming in a year later and checking on it, or how does it come back?
That's a great question, April. In fact, maybe we'll expand on that question a little bit and say, when does an agent get paid their commission? Let me tell you what a seller will try to do, and I'll tell you what I believe. A seller will probably try to say, oh, well, you don't earn a commission until it's a fully executed contract. It is my belief that when you enter into a lease agreement with option for purchase, you have fulfilled your responsibility and you should be paid your commission. Okay, so if you put that agreement in place, your job should be done. You get your commission paid and you're out of the picture. Now, if they let that expire and they're in a holdover contract and they need a new contract, they might call on you to write another contract and maybe, or maybe extend this contract. Okay. But my belief is don't take payments on it, because that's what a seller will try to do. Well, I'll pay you half now and half when they close on the property. Well, you've already put a contract in place where their goal is to close on the property. So you should be paid your full commission upon executing successfully this contract. Does that help you?
Yeah,
Okay.
so you're saying that even if the tenant chooses not to buy it, you've earned your commission just by doing the contract.
Exactly. That's my sincere feelings. Okay. Your job is to bring a ready, willing, and able buyer to the plate. Okay. You've done that. If this contract doesn't work out, then that's something that the buyer and the seller would either work through, or if it were me, I would, follow up and make sure that everything is going along okay. And if they needed any further assistance, but I definitely would ask for my commission up front. Okay. Because remember, in the listing agreement, it states that, in fact, I think it's in the verbiage in the beginning of this agreement too. It states that you are to be paid your commission on a lease or a purchase, or it describes all the different things that you are to be paid a commission on. And this is a lease agreement with an option to purchase. And so you're fulfilling that contract. Okay, now, any other questions?
Can I ask you a question about that?
Yes,
So
Sherry.
are you talking about the listing agent, or what about if there's a buyer's agent?
Well, you are the buyer's agent. Okay, because you're helping them to enter into a lease agreement with an option for purchase. So this could be, you have a listing on the MLS. Maybe they don't even put in there that they would consider a lease option, but maybe you call the agent and say, hey, I've got some people, they're really strong buyers. They've got $40,000 they put down up front. If your seller would consider a lease agreement with an option to purchase, the listing agent goes to the seller. They say, yeah, we would do that if they will put that $40,000 down. Out of that $40,000, you get paid your commission. The rest of it goes to the seller. And so you have done your job as the buyer's agent by entering into this lease agreement with option to purchase. Okay, does that answer your question?
Yes, except for there's no title company involved yet, right?
Not necessarily. Yeah, you could. I mean, you
I've
definitely.
done this before. I've done this before many, many years ago, before these forms existed, practically.
Yeah.
And we did our best, but nobody wanted to pay me a commission before it finalized. So I'm trying to figure out what forms are in place. Is there something that you send with this offer that says my commission will be paid up front? Do we have something, escrow instructions or some kind of form that lets
You would-
everybody know?
You would send this to the title company, and they would put together a settlement statement showing a lease or what the purchase would look like. Let's see if it. I know it says something. Offer with lease. Let's see what it says. I'm not sure. You know what? Ask me that question. Give me a call and I'll research it. I know
Okay.
there is a place where you're guaranteed to be paid, isn't there? If you're representing the buyer, who is the one that has agreed to pay you a commission?
So,
Buyer.
yes,
The
it
buyer.
should be in the buyer
The
broker.
buyer.
Well, I did that with my buyer and he would not sign the buyer broker because he knew he was gonna have to pay it out of,
Well, then,
This was
you
years- this
can't,
was
you
years
can't write a
ago.
contract. You cannot write a contract for them if he will not sign an agreement. You have
Yeah,
to
I
establish, you have to establish agents.
I didn't write this form. I didn't have this form. I didn't do it. But I took him to a thing, helped him meet with the people. They talked about how they're gonna do this lease, got him in there. My buyer broker had an amount in there and he said, I'm not gonna pay you this amount. This was a long time ago.
Okay,
So-
so Sherry, let me
so-
tell you what would happen today. Today,
Uh-huh.
if there was a problem with that transaction and the buyer said, well, Sherry Beck helped us with it, and the division says, we want to see a buyer broker agreement. You say, oh, well, I didn't enter into a buyer broker agreement. I just kind of gave them advice and stuff. That would still, you would still be in trouble because it's what is called implied agency. Okay.
Yeah.
So anytime you give advice or direction or any kind of help on a real estate transaction, you are entering into a representation contract, whether it's in writing or not. Implied agency used to be something that we said, no, it has to be in writing, but no, it doesn't. I've seen case courts that implied agency has been established and agents have gotten into trouble because of helping them when they thought, oh, well, I thought I could give them advice. No, you cannot, which gives us more power because I blame it on the state. I tell them the state of Utah, it is a state law, a division requirement that I enter into a representation agreement with you before I can ever help you in a real estate transaction. I can't give you any advice. I can't help you in any way unless you are willing to enter into a contract with me. Why would you want to help somebody if they're not going to do that? You know, my advice and the way I look at it, and I've had this happen a handful of times in my career, in my 33 years of real estate, I've let people go, you know, and move on to somebody that wants to work with you. So don't
Right.
put yourself in a liability position where you could get into
That's
trouble.
what my old brokerage from 20 years ago, they used to tell us to put 0 in that line about the buyer paying if you don't get paid by the listing agent, if you do something different. So I had a contract with him, but it has said 0. What I was trying to do was then say, okay, you're not buying a house now. I'm not getting paid. You're going to have to pay me. And that's the contract he wouldn't sign.
Okay.
So I
That-
screwed myself, but that was in the olden days when our brokers told us.
Yeah.
that-
So
to put-
Sherry, right now, just so you know, the Department of Justice sued NAR because of misstatements that agents are making, and the National Association of Realtors made a commitment that we would teach our agents that when you are asked who pays the commission, you should never say, oh, the seller pays the commission, so you don't have to worry about it. No, you have a buyer broker agreement that says that the buyer will pay you X amount a percent or how, or X amount of dollars in a commission. But then it further says, if you buy a home on the MLS, then the amount that they're offering will satisfy, what will be credited toward the commission that you've agreed to pay. If it's less than the agreed amount, then it says that the buyer will be responsible for that. However, you can do an addendum to that contract and say, no, I will accept whatever the offering, the commission offering is on the MLS. Because some people say, well, I don't want to have to pay an extra 0.5% if the property is only a 2.5% commission. So then you would use an addendum to the buyer broker agreement and agree that you would accept whatever commission is being offered on the MLS. Okay. No longer can you say that, oh, you don't have to, that if you put a 0 in there, that's exactly what you're probably going to get is 0, especially on a possible lease option or any kind of a purchase. Okay. So you want to make sure that you fill that out correctly.
So
you have a
from
question?
now on, if we're willing to take whatever is offered on the MLS, the 2.5%, we have to have an addendum stating that, and then put the full amount, the 3%.
Well, or if you know what the amount is, Sherry, then you can just initially put that amount in the regular contract. So if you know that you're putting an offer in on a particular home and they're only offering a 2.5%, then on your buyer broker agreement, just put that the commission that the buyer is going to be responsible for is 2.5%, because then the verbiage below that says that the amount being offered on the MLS will satisfy that payment. Okay. But if you I always put a 3% on there, but I tell people that, that if it's less than that, I will accept whatever is less than that. And if they say, well, I want that in writing, then I do an addendum. Yes. That's what addendums are for. Addendums are to amend anything that's in a contract, isn't it? You don't cross through something, and that is the wrong way to do it. The proper way to do it, and why they've created addendums for all of these things, is because the proper way to do it is to do it on an addendum. That's how you amend a contract, is through an addendum.
Hey, Don, let me back up just a little bit on that. The buyer broker states that whatever percentage you have in there is what the client is responsible for, unless you're paid through the MLS. Then it states if the MLS is less than that, whatever you're paid through the MLS satisfies the agreement. And so we won't go after the difference. We're not required to go after the difference. You're not required to if it's through the MLS. Now, if it's a non-MLS property, then whatever you put in there is the commission amount. And then you would have to amend it if there's not an MLS agreement.
Is that new verbiage? Are you saying that it's saying that
I don't know how long it's been in there, but the buyer broker does state that whatever is paid through the MLS is what will satisfy the agreement.
And it doesn't say anything about going after that the buyer will be responsible for any.
It only says that there's a difference that is non-MLS that it will be taken care of.
Okay.
So let me back up again on the lease option. If you're on the buyer's side, you have a little bit less risk here because with the buyer side, if it's on the MLS, once it closes, you're guaranteed through the agreement through the MLS to get paid. Now that may be a year out if you have to wait that long to get paid, but you will actually get paid through that commission agreement. On the seller side, it's a little bit different. If you represent a seller and you're accepting a lease option, then at that point, you probably need to go to your client and get that commission paid up front and then disclose that off of, pay your buyer's agent once you get paid there. Because it's quite often that if it gets to the end of that lease agreement and the whole thing falls apart, that you're not going to get paid that commission. And a year later, it's going to be pretty hard to go after it. So on the listing side, I would tell you to go after that commission, not go after it, but advise the seller that he has, you've fulfilled your part of the responsibility and he's due to pay that commission.
Okay, so here's what I'm bringing up that you would have to amend. So right here is the buyer broker agreement. Here's where you put the amount of the commission. And it says, if the property acquired by the buyer is listed with a brokerage, the buyer agent commission paid to the company by the listing brokerage shall satisfy the buyer's obligation for the brokerage fee shown above, provided that the BAC is not less than the amount shown above. If the BAC is less than the amount shown above, buyer will pay the difference at closing. Okay, so it does say that the buyer will make up the difference. If the property is not listed with a brokerage, in the absence of a commission agreement with the owner of the selected property, the brokerage fee shown above shall be paid by the buyer. Okay, so that's why that's why if you have a 3% here and the fee that's being offered is 2.5%, and they say, well, I don't want to pay more than that, you know, you would do an addendum to amend this section. Okay, does that clear that up?
Okay, so we do need to do that, Dana. Okay, that's what I
Hey,
need to
Don,
know.
would-
Thank you.
Don,
Yeah,
can you go
Lane?
back down and read further down through that paragraph you were just in?
Say that again.
Go back and read through that paragraph all the way to the bottom. I think it answers the question.
It says, okay, provided that the BAC is not less than the amount shown above. If the BAC is less than the amount shown above, buyer will pay the difference at closing. If the property is not listed with a brokerage, in the absence of a commission agreement with the owner of the selected property, the brokerage fee shown above shall be paid by the buyer. Unless otherwise agreed to in writing by the buyer and the company, the brokerage fee shown above shall be due and payable on, if a purchase, the date of recording of the closing documents. If a lease, the effective date of the lease. See, there's what I told you. That's why this states that you should be paid once you execute that lease. Or if an option, the date of the option agreement is signed. If the transaction is prevented by default of the buyer, the compensation shall be immediately payable to the company. So if the buyer just backs out, you actually could go after them for the commission, but we never do that. You don't want to become known as an agent. We don't want to become known as a company that goes after people to force them to pay, you know, a commission. So I mean, I always take a soft sell on that. And I have very few people that ask me to put that in writing, but if they want me to, I will certainly do it. Okay, does that make sense to everybody? You understand all that now?
Yes, thank you.
Whether it's a lease or an option or a purchase, you deserve your commission once that is executed. Okay, all right. And what if you want to try to get a 3% when they're only offering a 2.5%? What can you do? Let me show you something. Okay, let me go back and show you there is a form for that. And this is the form that you should use. It's called brokerage, real estate brokerage payment addendum. Okay, so look what this says. Seller's payment to buyer's real estate brokerage. Seller agrees to pay blank dollars or blank % of the purchase price to buyer's brokerage. This payment shall be made in addition to any other compensation offered by the seller's brokerage to buyer's brokerage. The provisions of this addendum shall survive closing. What is that saying? If there's a 2.5% and your buyer says 3%, you tell them, I'm not going to come after you for the additional, but the only way that we can increase that to a 3% is if we do this form, because the buyer has to ask the seller to increase the commission. A company cannot ask another company to do it. An agent cannot ask another agent to increase the commission. This is a form signed by the buyer and the seller, where the buyer is asking for the seller to pay an additional, and what you would put here is 0.5%, because if they're already offering 2.5%, it says this payment shall be made in addition to any other compensation offered by the seller's brokerage to buyer's brokerage. Okay, does that make sense, everybody? I hope so.
Yeah.
Okay. Good questions, you guys. I love it. Okay. Couple of forms.
I have a question.
Yeah.
That seems contrary to what we've been taught, that commissions should not be part of the real estate purchase contract.
They can't be unless it's between the buyer and the seller. I know. This is a state-approved form. It's not a form that I created. It's a form that was created particularly for this purpose. So yes, you can include this as an addendum. Okay.
And the reason is because it is between the buyer and the seller, not between the brokerage and the seller?
Yes, it cannot be
Okay.
between the brokerage and the seller. The seller, who does the seller have a contract with? The listing brokerage. Who does the buyer have a contract with? The buyer's brokerage. So therefore, the only one that can ask for additional commission is the buyer asking the seller. This was a form that was created, I believe, after the Department of Justice sued NAR because they wanted everything to be full disclosure. So this is full disclosure. And guess what? They can reject it. So if they do reject it, and your buyer say, well, now what do we do? They say, well, don't worry about it. I'm not going to come after you for the extra 0.5%. Well, I want that in writing. Then you would do an addendum to the exclusive buyer broker agreement. Okay.
Thank you for walking that through with me.
Yeah, of course. You guys, there's a form for everything. There is. And I'm going to show you a couple more that I didn't even know were on here. Okay. I think that's the next one. This one, I'm so glad to see it. I didn't know it was on here. Let's see. Got that one. Purchase and sale agreement for commercial real estate. This is not found under the commercial real estate forms. I found this when I was searching for purchase agreements. So we didn't used to have a purchase and sale agreement for commercial real estate. Now we have one. So I didn't have a chance to really look this over, but it's going to be very similar. It's quite a long, lengthy, for 12 pages. So if if you're doing a commercial real estate transaction, call your broker and we'll help you through this. We'll learn together. But there's 12 pages of this, and but I was so excited to see it. Just like I'm excited to see this next one. Didn't know that it was on here. Right now, because the building boom is going crazy, even through the times that we're going through now, the builders are starting to ramp up again. And so there's a lot of raw land sale, isn't there? Well, guess what? They created a purchase and sale agreement for commercial real estate, fundamental terms of offer to purchase unimproved land. So they consider that a commercial real estate transaction, and they have created a form. And this is through the CCIM, which is, it's a national chapter. It's the highest designation that a commercial agent can get. So anyway, now there is an agreement for purchasing raw land. I was so happy to see those. Again, I'm not going to go through those with you, but if you run into a situation like that, we'll help you through it. We'll learn together. Okay.
Okay. So and one question, sorry about that, Don.
No, you're good.
So as we are practicing residential real estate, if we come across a commercial property or land, we can still sell under these agreements then without
Yes.
any designations?
So let me explain that. Very good
Okay.
question. Thank you for asking that question. If you have a residential real estate license, you are also licensed that you can do commercial real estate. I don't understand it. I don't agree with it, but you can. That's why we have some commercial agreements on here. Do I recommend it? No. I would prefer that we get either one of our agents who's a specialist in commercial, which we have a handful of them. I would rather have you do a referral and get paid a referral fee by turning it over to somebody that knows what they're doing. Okay, either that or say, hey, I want to learn how to do it. So I'll give you 50% of the commission if I can shadow you. There's a couple of ways to do it because commercial is a totally different animal. The last commercial deal that I did, if you guys know where Chinatown is on State Street, downtown, I sold to an Asian businessman an entire block right next door to Chinatown. It's where there's an Arby's, in the back, there's a car auto repair shop and whatnot. And he's already started adding some more Asian stores and whatnot to it. And it was a $3.2 million deal. I don't even feel confident enough to work on that because I don't do that much commercial. So guess what I did? I brought in Jeff Reynolds. He is my commercial expert. He led us along the way to make sure we didn't miss any inspections or any kinds of things that we needed to do specifically for commercial. Nancy Zhang was the one who brought us the lead. So she did all the footwork. She did all the going and getting signatures. She did anything that we needed her to run and do things. She was awesome at doing that. And I was the negotiator. So we had a 3-person team which you will find in real estate all the time, that there's at least a couple of people that are on a team, or they have a whole team of people that are working on specific commercial properties. That is what I would recommend, because it's important that you do it right, and that you make sure that you're dotting all your I's and crossing all your T's. So, but yes, the real answer to that is yes, you can do a commercial transaction. But if you do, get your broker involved, and if we find it's too crazy of a transaction, we will probably tell you that we need to refer it out. Okay. All right. Thank you for the questions. Anybody have any other questions about that? Okay. This next one, I'm seeing a lot of too. Option to keep the property on the market. This is what is commonly referred to as a time clause addendum. This is in the amendatory language too, that you can add to an addendum that has other things on it. I prefer to do this as a separate addendum because it's important to make sure everybody understands. This is when when you have somebody that comes to you, you're the listing agent. Somebody comes to you with a good offer, but they have to sell their house. So they're going to have a contingency on the offer. So what I always advise my seller, well, we can accept their offer, but we can do it with a time clause, which keeps your property active on the MLS. And then if we get another offer that has no contingencies, we give our first offer, we give them notice that we've accepted another offer, and then they have however many hours or days that you've built into this to remove their contingency. Otherwise, we can move on to the second offer and accept that one fully. Okay, so this is the addendum for the time clause. So if somebody sent me an offer, but they had a house to sell, we would counter back with this particular addendum that talks about, and normally I give them, this used to be called a 72-hour time clause addendum. Let me tell you why it used to be called a 72-hour one, because let's say that you get an offer on a Friday night, or you have until Friday night to respond. You get an offer, and you've got an offer already on it that you're going to execute your time clause. So you send on a Friday night, you send the form telling them that we've accepted another offer, your time frame is starting. Well, if it's on a weekend, they might need to check with their lender to see if there's another way that they can do their financing so they can remove their contingency. So 72 hours gives them the weekend plus 1 day to be able to get to their lender and to be able to talk with them and see if there's any way they can remove their contingency. So that's, in my opinion, that's a fair way to do it. That's why I always suggest 72 hours. Okay. So so here's what I would counter back with this time clause addendum. Then the status that you change the property to is not under contract. It's active T/C, active with a time clause. Will agents still show your property if it's active TC? Yes, because an agent knows, aha, I've got a buyer that doesn't have any contingencies. They've got an offer they've accepted that has contingency. So we're going to go ahead and submit our offer and see if we can get it accepted. And then they can tell their first buyer that they've got another offer, and maybe we can bump that first buyer out of it and we can buy the home. So an active TC is just almost like being active. Okay. So that's yeah.
Oh, hi, Don, this is Ruben. So what is the difference? I mean, I guess when you have this time and also a backup, you know what I mean? You can put it also as a backup instead of a timing, right? What is the finish?
A backup offer is you're negotiating and accepting a second offer, which is considered a backup offer. So that backup offer, if your first offer fails, that backup offer moves into the primary position automatically if you've accepted that as a backup offer. This one is you're accepting the offer, but leaving it open so that if you get another offer, you can bump them out of it if they can't remove their contingency. The backup offer, you've accepted their terms and you've accepted the fact, you might do a backup offer with a time clause, okay? If they have to sell a house too, you might say, well, we want to do a time clause just in case, you know, the first offer fails and you move into the primary position and you still haven't sold your home. We want to make sure that, you know, we've got a time clause on it so that we can still market it to maybe find somebody that doesn't have a contingency. So the difference is the backup offer, you negotiate just like you do on the first offer. You accept their offer, but you accept it in a backup position, which means that when your first offer fails, they automatically move in as the primary offer. Okay? That explained it to you?
Yes, thank you.
Okay, you're welcome.
So
Okay.
is there a chance to lose both offers? If the second one is waiting on the first one for 3 days, could they back out?
Yeah, of course they can. With written notice, they can back out. They can let timeframes expire. When the first offer fails, we give notice to that second offer. And at that point in time, they can say whether you maybe might change the terms of the offer or whatever, or they could cancel at that time, because even if they move into the primary position, they're going to have a due diligence period. They're going to have a financing appraisal. So there's a lot of opportunity for them to cancel if they want to, correct? Oh,
Yes.
and just so you know, on a backup offer, somebody does not have to put down earnest money. They don't have to put down the earnest money until their offer moves into the primary position. So what if that backup offer, they go out and they're still looking at homes and they find one that they like? Well, their earnest money's not tied up because they're not in the primary position on a home yet. So they can move in, put earnest money on that new house that they found, and then give notice to the other home that they've found another home and they're withdrawing their offer. Okay. Those are good questions, you guys. Those are all
At that
scenarios
point-
that happen. Yeah.
At that point, would you require a withdrawal of offer form, or do you just take the agent's word for it?
You definitely need to put it in writing. Yes. Yeah. You would definitely put it in writing. So you would do, I think a withdrawal of offer form would work. There's a withdrawal of offer, there's a cancellation, buyer cancellation. I think either one of those would work. I'd have to look at them to refresh my memory and make sure. Okay. This next form is you have an offer that your seller has accepted, but it has a time clause. So we've accepted it, but we've got a time clause. Now we have a new offer that came in and we've accepted that because it doesn't have a contingency. So this is the form. There's a form for that, you guys, a form for everything. This is the form that you would use for the seller's notice to buyer of an accepted offer. This is the time clause notice. This is saying that, number one, addendum number blank to the Rep C contains an option to keep the house on the market, time clause. Number two, this seller's notice informs buyer and seller, informs buyer that seller has accepted another offer subject to the rights of buyer provided in the Rep C. Number three, buyer is advised that upon receipt of this seller's notice, buyer shall remove the applicable conditions from the Rep C in writing within the agreed upon time, or by failing to respond in writing to this seller's notice, allow the Rep C to automatically become canceled, in which instance the earnest money deposit or deposit shall be released to buyer. Okay, so on a time clause, earnest money does have to be deposited because the seller's accepting an offer with a time clause notice. But number three says that if you can't remove the contingency, you get your earnest money back. Okay, so this would be the notice that the seller gives. We've got a new offer, doesn't have any contingencies. And so we're starting the clock on that 72 hours or 48 hours, however much time you give them. Okay, then this is the form, buyer's notice to seller of removal of conditions, time clause notice. If the buyer is able to remove the conditions and take away that contingency, whatever it is, this says addendum number blank to the Rep C contains an option to keep the house on market, time clause addendum. Number two, this buyer's notice informs seller and buyer, seller that buyer removes all the conditions checked in section 1B of the option to keep house on market, time clause addendum. Very simple. Is it saying Buyer is saying to the seller, hey, we've got it worked out. We're removing the contingency. So we want to move forward with the purchase. Okay. And let's see. One last one, you guys. We're almost done. We're going to be done on time, I think. So any questions on that, you guys, on time clause, on these three notices? They work hand in hand. Time clause notice, you accept a contract with a time clause. Then this is the seller's notice. If you get another offer, seller sends a notice to the buyer, hey, this starts your time clause ticking because we've got another offer. If the buyer can release the time clause, they use this notice to send to the seller and say, we are hereby removing our contingency. Okay, those work hand in hand. Okay, last one. Unrepresented buyer disclosure. You guys, this one is so important for you to listen to what I'm going to tell you. Okay, I'm serious about this. I met with the Division of Real Estate, me and Bill Telford. So I know for a fact what their posture is on this. Okay, so first of all, look in bold and in caps. You should always read this. When you enter into a discussion with a real estate agent regarding a potential real estate transaction, you should, from the outset, understand who the real estate agent is representing in that transaction. What follows is a brief but very important explanation regarding agency relationships and the real estate agents involved in this transaction. Okay? So this is boilerplate stuff. I know this is on other contracts too. Seller's agent, buyer's agent, agent of both buyer and seller. And then confirmation of agency in this transaction. And this transaction, again in caps, by signing this unrepresented buyer disclosure, the buyer acknowledges and agrees that the agent and the company will only represent the seller in this transaction as a seller's agent. The buyer acknowledges that the company and the agent have advised the buyer that the buyer is entitled to be represented by a buyer's agent who will represent only the buyer. The buyer has, however, elected not to be represented by a real estate agent in this transaction. So we're off the hook. We're representing the seller. You're on your own. So I had an agent yesterday, and it was the third agent this month. Oh, well, can I advise them and can I write the contract for them? Listen to my answer. No. Okay. Here's what you can do. Here's what the Division of Real Estate says you can do. If you have an unrepresented buyer, and this might be an opportunity for you to get the other side of it, maybe at a reduced rate. The Division of Real Estate says all you can do is you can put in a manila folder or a whatever folder you want, blank copies of the forms that they need to fill out. In fact, it'll probably scare the buyer to death unless they've done a few of these, unless they're an investor or something. Give them the blank forms and say, these are the forms that the Division of Real Estate requires that a buyer fills out in order to do a transaction. Okay? They have to fill it out themselves. Now, when you say, can I write the offer for them? No, you can't. But you are representing the seller, so you can answer their offer. If their offer is all, things missing on it and everything, then you would do an addendum, stating that section 5 of the REPC states that shall be changed to read that Don Zimmerman with Fathom Realty represents the buyer or the seller, and that the buyer is unrepresented, or whatever you need to address to protect the seller, you can address it in a counter offer or addendums. Okay. I did one of these a few years ago. That was a mess. I mean, the buyer wanted to do it themselves, and it was a total mess. And I told him, first of all, it was such a mess. I gave him the paperwork back and said, I'm sorry, I've shown this to my seller and he's rejecting your offer. Not based upon the offer itself, but based upon that this is a mess. And you either need to pay more attention to what you're writing into this paperwork, or else get somebody to represent you. The comment from the buyer was, well, could you do it? Could you write the offer for us? And I tell him, if I write the offer for you, I'm going to be representing you, and I have to get yours and the seller's permission to be a limited agent. And then I'm going to have to pay fees to my company for that. And it's worth it to you and to me, you know, so I would do it for 1.5%. Okay. Whatever you want to do. But sometimes it gives you the opportunity to win the other side of the offer as well. But you cannot advise them. You can't even give them verbal advice. That could be construed as being implied agency. Okay. But what you can do is you can answer anything that they send to you in the form of a counteroffer. And you do it always from the direction that I am representing my seller totally. I have no ties to the buyer. I have no relationship with the buyer. I have no fiduciary duty to the buyer because they chose to be unrepresented. Okay? Everybody understand that? Yes.
Did I hear you say that the company Fathom Realty charges 1.5% to do a limited agency?
You can say whatever you want to say.
But you said we do have to pay additional fee, or?
If you represent two sides, that's two transactions, isn't it?
So it's going to be those. Okay.
On limited agency, not only do you pay an additional $550, but because it's limited agency, you're going to pay an additional $200 on one of the sides. So you're going to pay $750 on the buyer's side and $550 on the seller side. So you're going to have to charge more than that $750 if you want to make any money on representing the buyer. That extra $200 is a liability fee because there is a higher liability in transactions where you are a limited agent than there are when you're only representing one side. And I totally agree with that. I hate an agent being a limited agent because you cannot serve two masters. You have to be so neutral that you don't give one party or the other any advice that's going to give them advantage over the other side.
Right.
Okay. There are more lawsuits on limited agency than any other kind of transaction. However, I'm okay with limited agency. So being a limited agent is when one agent represents both sides, but limited agency can be when two agents, one represents one side, one represents the other, but they're within the same company under the same principal broker. So limited agency is okay in my book, but being a limited agent, even though the state of Utah allows it, I think it is a formula for a lawsuit. Okay. So anyway, you have to be very careful. Okay.
One more quick question. Is there a form? So like if you're representing a buyer and they filled out an exclusive buyer agency agreement, is there a form if they decide they really want to break that agreement for them to do so? To let the buyer out of the exclusive agency agreement?
Of course. If you agree to it, there is. Let's show you. Okay. There is a cancellation for both a listing and a buyer broker agreement. So I think it's called cancellation. Yep. Termination of the exclusive right to sell listing agreement and agency disclosure. That's for the listing. Or cancellation and termination of the exclusive buyer broker agreement and agency disclosure.
Okay.
Okay, now, since you brought it up, let me show you one of them real quick and show you a danger zone. Okay, so you can release them from their contract. This says mutual termination of the agreement. Both parties agree to mutually release each other from any and all obligations, claims, liability, and demands arising out of the agreement, including but not limited to the agreement's protection period, unless checked below. I would never release an agreement if somebody says, yeah, we're gonna we'll call you in 6 months, we're gonna wait for our taxes to come in or whatever. Then I would always check mark this: the agreement's protection period is not canceled or terminated, and if I have a 6-month protection period on their agreement, that's still in full force. So they can't go back, and they cannot go back and wheel and deal on a home that I showed them while their buyer broker agreement was in place. So I would always,
that you showed them. Okay. But if they found a new home on their own, then
if they found a new home on their own, then you're out of luck. Okay.
Got it.
All right, everybody understand that?
Thank you.
You guys, great questions. I hope that this has been helpful. That's why we're doing one a month. Thank you for being here. Do we have any questions before we go? You know what? I didn't check the chat box. Looks like there's something in the chat. How can we make our commission part of the REPC? I think we showed you that. You can't unless the buyer asks the seller on the brokerage fee payment addendum. I understand that there is an MLS listing agreement. The buyer's agent is paid through the MLS. Broker agreement is the standard non-represented seller commission agreement. Work with a lease option. You know what? Call me or Jeff, and we'll we can go through your. That's a complicated question that we'll have to check into the forms to make sure we're answering your question correctly. Okay. All right.
Don,
Any
they
other
said
questions?
all questions were answered. Their
Okay.
last comment was all questions were answered. So I think
Okay,
they're good.
perfect. Okay. Anybody else have any questions? Looks like there's one more.
In regards
Thanks,
to
Don and
the,
Jeff. Yeah.
in
Yes.
regards to the limited agency, I don't remember on our Fathom agreements, like our agents to Fathom. When it comes to limited agency, we pay the additional fee if it's above a certain amount. Is that correct?
No. Limited agency is $200 just for being a limited agent. Okay. An extra $200 because you're representing both sides. When you pay an extra fee, and you guys, this company is great on this part. You have to do a $2 million deal or more before you pay any extra above the $550 that you pay on each transaction. Okay. Then when it goes above 2 million, for every 100,000, you pay an additional $25. So on a $3 million deal, $25 times 10, you'd pay $250 extra on a $3 million home. That's very fair because I know how E&O insurance works, but not on limited agency. Limited agency is an extra $200 simply because you're being a limited agent. Okay.
Okay. And is that on each side that you're representing, or just 200
No,
total?
just on one side.
Okay.
Okay. So you would pay $550 on one side and $750 on the other side. Okay. Good question.
Hey.
Thank you.
Hey, Don, I have another question.
Yeah, Ruben.
So I was working with a client with seller financing, and you didn't cover this option, and I start seeing it, a little bit more. And so I guess I can ask you some questions directly, if I don't want to tie up the time for others.
Yeah. There is a seller financing addendum to the real estate purchase contract.
Right.
So remember, it's an addendum. So you have a purchase contract already created, and then this would be an addition to that REPC, that real estate purchase contract. Call me if you have any questions on that. Yes, it's a different animal as well. Okay.
Yeah, because there are two ways of doing this, right? There's one thing with contract for deed, and the other one would be
There is contract for deed or
right.
yeah.
Okay.
Or an all-inclusive trust deed.
Yeah.
Yeah. So call me if you have specific questions about
Yeah,
that.
I will. Thank you.
I took some classes on contract for deed. A lot of people are afraid to do them. I can tell you what the ins and outs are of them. So yeah, I'm not afraid of them anymore. I used to be. Okay.
Well, to me, like contract for deed, kind of like similar to option, right? Because on the contract for deed, you don't like title. I mean, you don't in the title right away, but it's in the future.
Yeah,
right?
you get a notice of interest against the property,
Right.
which is just like you're the owner of the property. You can still sell it or do whatever you want with it.
Yep.
But the thing that I don't like about contract for deeds is they give you a short curing period. So usually they'll build in a 30-day. If you are late with your payment on the 31st day, the seller can initiate the release of that notice of interest and can take the property back.
Okay.
But call me if you have any questions on that. Okay.
All
right. We have a question from Laura. If you have a 7% listing representing the seller, do you charge buyers 1.5% or fee in addition if the house price is under 2 million? We do not charge anything under 2 million, any additional. Doesn't matter if you have a 7% listing or whatever you have, you get the rest. Okay. If you become a limited agent, you're still going to pay the extra $200. Okay. All right. You guys, good questions. Anybody else? I'm trying really hard to keep these classes to an hour, but I realize doing them once a month, sometimes we might.
Wet, it has to be removed, and we don't want it removed until.
Anybody have any other questions? If not, okay, let me remind you of a couple things. So
not leave it.
This is the third Wednesday. The first Wednesday of every month is Tech Tip monthly, and the third Wednesday of every month is Forms and Free For All monthly.
To rest and not.
And so make sure you know that, and let me give you a date of something that you need to put on your calendar. So save this date, you guys. Save the date of March 16th. You got an email. Maya sent out an email yesterday. March 16th is our awards breakfast. It's everyone who did 2 million or more in production last year. You will receive some kind of an award. Plus, some of you have been selected as the MVP award, and some of you new agents as the new agent, the Rookie of the Year award. Each office has those particular categories. I know one of the questions we have is if we were with Aubrey and Associates, did anything that we did with Rob, does that count? Yes. They usually don't count it, but they have allowed Aubrey and Associates, Aubrey and Associates transactions to be counted along with any transactions you've done with Fathom. Same thing with iPro. We sent a spreadsheet to Fathom that had all of your numbers on it, so that will be included with whatever you did with Fathom this past year. But remember, it's awards for 2022. Also, 1099s. If any of you are still having trouble with 1099s, please email agent services at fathomrealty.com. Let them know here's the most common things we're finding. Some of them were made out in somebody's personal name when it should have been in their entity name. They have an LLC. So rather than their LLC, they put it all in their personal name. So email agent services and explain in detail what the problem is, and within 5 to 10 days they will have it corrected. So the sooner you do it, the sooner they'll have it corrected. Another one is don't go into the report section. Agents are trying to pull their numbers from the report section, and it's not working right. So you can go to the MLS, go to your own records, and add up your production. But don't go to the report section of IntelliAgent. It's not working correctly at all. So those are the things you need to know. And thank you so much for being here. We'll be here again next month on the third Wednesday of the month, or maybe not, because the third Wednesday might be, if it's close to the 16th, we won't be doing it. But you'll get emails and texts from Maya keeping you informed. Okay. All right, you guys, next week, the fourth weeks of the month are our team meetings. So next week we have Clearfield team meeting on Monday. We have Midway team meeting on Tuesday. Union Park and Orem team meetings are on Wednesday of next week. Okay. So we look forward to seeing you all there too. All right. Thanks everybody for being here. We appreciate you. Please let us know how we can serve you. And if you have any questions, Jeff and I are always willing to help. Okay. Thanks so much. Have a wonderful weekend coming up. Okay. Bye-bye.